state of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the state of Iowa is now in session.
Thank you. Please be seated. Welcome to this session of the Iowa Supreme Court at Drake Legal Clinic. It's always a pleasure to be with you. We have one case that will be submitted this morning. That case is John Baker and Valerie Baker versus City of Iowa City, Iowa, and Iowa City Human Rights Commission. We'll proceed with the appellant's argument, and Mr. Pitton, you may proceed.
Good morning. May it please the court. My name is Michael Pitton, and I represent John and Valerie Baker, the appellants in this proceeding. The issue before the court is whether a city which enacts an ordinance which is unconstitutional on its face and infringes on fundamental rights and then prosecutes an individual through a municipal agency based on that ordinance is liable under 42 U.S.C. 1983 as a matter of law. By way of introduction, this court had decided in May of 2008 that the Iowa City Human Rights Ordinance was unconstitutional to the extent it failed to recognize the state express exemption for small employers. That exemption is based on freedom of association, as was referenced by Professor Bonfield just prior to the enactment, and as this court quoted with respect to the purpose of that exemption.
Well, but the case turned on a state constitutional issue, did it not? Namely, that the ordinance was preempted under state constitutional law. Isn't that your reading of Baker?
My reading of the case, Your Honor, is that it turned on both state home rule authority and freedom of association. Freedom of association, of course, being a federally guaranteed right as well as a state guaranteed right.
Sure, but not all freedom of association is constitutionally based. I mean, it is true that Professor Bonfield talks about the notion of freedom of association, but the United States Supreme Court, at least, has been rather narrow in its construction of freedom of association, dealing with intimate relations and so forth and so on. Don't you agree? And it seems to me you need to establish a federal constitutional claim of freedom of association and not a more generalized claim of freedom of association.
Well, a couple of points to that, Judge. The federal cases, the U.S. Supreme Court has said that freedom of association is not limited to family relationships specifically, and this court addressed the intimate relationship between a small employer and small employee in its Baker 1 decision.
Well, we didn't characterize it as a constitutional limitation, though, in Baker. We do use the term freedom of association, but freedom of association can mean a lot of things. The Roberts case, which you cite, seems to really focus in on what the United States Constitution requires of freedom of association to be constitutionally protected. Why don't you share with me what aspects of Roberts you think supports your claim in this case?
Well, the closeness of the association that's involved, the need for a trust relationship between the parties, the interaction that's necessary, and the shared personal commitments of the parties are all referenced. And then in this court as well, this court had stated that the ordinance was unconstitutional because it thwarted the legislative intent and ruled that the city's ordinance constrained and injuriously affected them as a small employer based on associational rights.
How often do the Bakers return to Iowa and live in the apartment?
Several times a year, Judge. They return, and it's not on a scheduled basis, but they return quite frequently and then stay in the home with the resident manager and cohabitate in that respect. And of course, here we're talking not just about the relationship between bakers collectively and the resident manager, we're talking about a family business between two spouses.
Didn't your summary judgment papers, though, suggest we were really only talking about 1 week per year?
That is a minimum that they do come down, but that does occur oftentimes more than that. For example, when the flood occurred in Iowa City, they were here quite often and stayed, and Mr. Baker stayed for a lengthy period of time in the home. So it varies on the need, the circumstances, the timing of the year. At a minimum, it would be once a year. But I would suggest that once a day is close enough that you want to make sure that the person you're staying with is somebody you feel comfortable with and shares the value that you have, preserves the home that you have, the antiques that are in the home, and the other issues of trust related to that relationship. So then the question becomes, is this a federally protected right under freedom of association? The freedom of association that this court recognized back in 2008 that would give rise to a 1983 claim. And we believe there's ample law that reflects that, both in the case of...
Counsel, do you have a case where an absentee landlord in a business relationship hiring a property manager some distance away was held to be, interference with that was held to be to violate a freedom of association under the federal Constitution?
Justice, I don't believe that there's been a case decided either way on that specific fact question.
Well, but the Roberts case does say that business relationships ordinarily are not protected by freedom of association, does it not? I mean, it's a general statement in Roberts, but why isn't this more of a business relationship than a kind of an intimate, close working relationship? I mean, it's not quite the same as, say, running some kind of restaurant where one spouse is in the kitchen and the other spouse is waiting tables and that kind of thing on a daily basis. This seems more akin to a business relationship at a distance with some sentimental overtones.
Well, the underlying facts that are set out in the appendix, and I'd refer the court to 257 to 261, relates to the nature of the qualities and the skills that the Bakers were looking for. Here they were talking about qualities of trust, reliability, initiative, and skills that related to showing the property, negotiating the leases, outside maintenance, including use of a ladder, lawnmower, snow blower, cleaning gutters, living with the person as need be, preserving the character of the home, the antique furnishings and fixtures, and of course this was a home that Mr. Baker had grown up in, had been in the family for 70 years, and respect his sentimental value to the home as well.
Well, save for the living together piece, all of the criteria or job requirements for this position seem to be similar to any employer's interest in when they're hiring an employee, and so it still strikes me that, except for the sort of sentimental overtones, we're talking about a standard kind of employment relationship, aren't we?
But are we? If it's in the context of a small employer, bear in mind we're talking about a husband, wife, and their trusted resident manager, whom they periodically cohabit with, who they have to deal with in terms of leases, problems, tenants, repairs, and everything else. This is not one of the larger corporations that manage many properties that call somebody in to do things. This is a husband and wife that has to make employment decisions with someone they can trust. And would that relationship not be entitled to the protection that this court not only recognized and Professor Bonfield addressed, but also the Supreme Court talked about? And the cases in the Supreme Court have not limited, or decided by the Supreme Court, have not limited freedom of association to any particular context. They have not limited it to family, marriage, and such, even though we have a family business here.
And that's part of what scares me is where would this stop if we constitutionalize and provide a Section 1983 attorney fee recovery, which could be many tens of thousands. I'm tempted to ask what your fees are in this case so far. Anytime a city official or agency makes a mistake with a small employer, that's a federal constitutional claim. I mean, can you address where the lines are drawn?
I can, Justice. Here, what we're looking at is a situation where an ordinance is facially unconstitutional, and there were 3 levels that we described with respect to the involvement with the bakers. 1, passively, you enact the ordinance. 2, you restrict conduct. And 3, you actually commence legal action based on an unconstitutional ordinance. And there you've seen the cases of Carlos and Fields and such, and Harmon as well. But in terms of what kind of parameters should we look at for the future, where an ordinance is facially unconstitutional, the ordinance is contrary to an express statutory exemption or stated public policy, the ordinance affects fundamental rights, and here we talk about several, including freedom of association, and property or liberty interests are implicated, which the district court found in this case, property interests to be implicated. And when those circumstances apply, we believe that Section 1983 should be available to the plaintiffs in order to redress their wrongs and to obtain Section 1988 attorney fee relief.
Hypothetically, if the bakers didn't have a practice of coming back to stay in the building, would you still have a freedom of association violation?
I believe so, but not as compelling. But the reason I believe so is because of the underlying policy behind the small employer exclusion. I'm not sure how we can stand here and second guess the legislative intent that was recognized in 2008 and say that if you have a small employer and the small employer relationship is one that's subject to associational rights and freedom of association, that we're going to let this small employer have those rights, but not the other small employer. So to the extent that one has to turn the dial and determine this on a case-by-case basis, that seems to open up problems for an equal protection argument. So with that in mind, and the concern here, of course, is that the city and the commission will say that there is no remedy. Yes, we violated the constitutional rights of the bakers, and yes, we violated home rule authority, the Iowa Constitution, the statutes, but there is no remedy to the bakers.
Well, if the sole constitutional violation was a state constitutional violation, what violation of federal law is involved in the case?
In this case, there's a violation of 4 aspects of federal law.
I know, but I want to set that aside. If I take it as true, but maybe you disagree, but I take it as true that 1983 is not available as a remedy for violations of state law. You agree with that or not?
I agree with that.
Okay, so we need to establish freedom of association or equal protection or due process under the federal Constitution.
Correct.
Okay.
And that brings it to the federal cases, or to the due process issue as well. Under the due process law, the enactment of a state right by statute is protectable under due process, under federal due process requirements.
Well, sure, but you had a notice and opportunity to be heard. I mean, there's no question that you're entitled to that much. I take it. I doubt that the city's going to take a position you weren't entitled to notice and opportunity to be heard. But of course, you had that. You settled the case at the end of the day, which is within your discretion, and I don't criticize that one whit. But my point is you had notice of what the city was claiming, at least, and you would have had an opportunity to present evidence at subsequent hearing and so forth and so on. And in terms of at least procedural due process, hasn't the city met its federal constitutional burden.
I would disagree that notice and an opportunity to be heard are sufficient. And in that regard, I would cite the court to not only the Carlo decision, but also the Fields decision that we address in the brief. These cases indicate, U.S. Supreme Court cases indicate that where a state enacted right is violated, that becomes a violation of the Due Process Clause of the 14th Amendment under the United States and entitles the claimants to Section 1983 and 1988 relief.
How do you get around our decision in the home builders case where those challenging the ordinance succeeded, or challenging the fee on a home rule violation, and yet our court stopped short of finding a violation of the federal Constitution?
Well, the home builders case, and I see the light has gone off. May I finish the answer?
You may respond.
Oh, thank you, Justice. I would distinguish the homeowners case, and that goes to the parameters that we talked about before as to a potential outline of circumstances that would warrant recovery. Homeowners case involved a tax. The taxing statutes are presumed to be constitutional. It was an economic measure, and as an economic measure, only a rational basis test is involved. There was no fundamental right involved in home builders, unlike this particular case, and no legal action, very importantly, no legal action or prosecution was commenced against the applicant, the appellants in the homeowners case, like it did occur against the Bakers in this case.
All right, you can sum up briefly if you wish.
Thank you very much. Based upon this, if the city and commission are correct, the Bakers were deprived of their property interests, had to expend substantial fees and funds after going through the process of district court, administrative proceeding, district court, Supreme Court, back to district court, and back before you again, all with no remedy. So after that, we would respectfully request that the court reverse the summary judgment granted by the district court, determine that the city and commission are liable to the Bakers pursuant to 42 U.S.C. 1983, enter judgment for attorney fees and costs under Section 1988, as well as additional attorney fees and costs incurred in the appeal, and remand the case back to the district court for a hearing on further damages. Thank you very much.
Thank you as well, counsel. Ms. Dulek, you may present your argument.
Thank you. May it please the court. My name is Susan Dulek, and I represent the City of Iowa City and the Iowa City Human Rights Commission in this matter. I wish first to address the motion to amend, which the lower court granted in error. Mr. Baker attempted to amend his petition in Baker 1 to include freedom of association. So at the time of Baker 1, freedom of association was not even part of the petition. He moved and it was denied at the lower level. He appealed it, but he did not brief it. And by failing to brief it, he waived it. And this court, specifically in Baker 1 on page 98, states, quote, he claims their actions violated his due process rights and the equal protection guarantee of the United States Constitution. There's no mention of freedom of association in count 2, the 1983 claim in Baker 1.
I don't really follow that argument because as I read Chief Justice Turnus's opinion, where she said that she rejected the mootness as to some of the federal constitutional arguments, that seems to me equally applicable, that analysis, to the freedom of association First Amendment arguments. And therefore, when the case gets remanded, as long as we didn't decide the issue one way or the other, it seems to me the trial court is entitled to take a fresh look at the case, as long as that fresh look is consistent with what we said in Baker 1.
The second reason the trial court erred would be an abuse of discretion. This occurred 4.5 years after the fact. The petition was filed in January of '05. The second motion to amend was not filed until June of '09.
Oh, but the amendment doesn't complicate things all that much, does it? I mean, so we know, I mean, the Bakers claim that this is not a typical business transaction. It has sentimental value. They live there. It's a husband-wife. I mean, we know kind of the basic parameters of the association claim. I mean, I'm not sure that adding this claim revolutionizes their pleading. Why don't you address that, please?
Certainly the city was aware of that, but the test set forth on abuse of discretion is, well, it substantially changes the issues. Going from due process and equal protection to due process, equal protection, and freedom of association and free speech is a substantial change.
But how is the city unfairly prejudiced by the timing of that amendment?
Well, the city then had to mount a broader defense because there were 4 issues rather than 2. But even if it's granted, the city did not violate his right to freedom of association. There's no intimate relation. It's a highly personal, is what the Roberts Court said, highly personal, such as marriage, childbirth, cohabitating, educating children. This is clearly, as Justice Apple and others indicated, a commercial relationship between an individual who lives in Pennsylvania and has a rental property in Iowa City, between a property owner and a tenant, between an employer and an employee.
Well, but they claim in this case that by virtue of the special nature of their relationship with this property and the fact that they do live together, they do cohabit in the sense that they do for a part of the year live in the same building. Isn't that enough?
Not a highly personal relationship contemplated by it's not a family relationship. It's purely commercial. It's all about money.
Well,
that's what makes a commercial relationship.
Not when you live with the manager. I mean, admittedly, I mean, you can make a de minimis argument, I guess, but for a week or some portion of the year they live in the residence, as I understand it, that's not exactly a commercial transaction, is it?
But the employee and the resident manager, that individual, is there as part of a commercial relationship, not because he is related by a brother, a sister, a cousin, not because marriage, but because he is paying to live there and Mr. Baker is paying him to manage the unit. But regardless, the key with freedom of expression is that it can't be used affirmatively. That's what the court in Norwood versus Harrison said. Invidious discrimination may be characterized as a form of exercising freedom of association protected by the First Amendment, but it has never been accorded affirmative constitutional protection. So had Mr. Baker gone to the administrative law judge hearing, contested the probable cause finding, he could have, as a defense, said, "City, you cannot hold me responsible in the employment context because I'm a small employer. And the First Amendment gives me certain rights as a small employer of association. So if I want to associate with people of my color, my religion, my race, I can do that as a small employer." It can be used as a defense. It cannot be used to sue the city for damages and attorney fees. That's clearly would be in violation of Norwood versus Harrison. And then turning to the other challenges, the due process one, which Mr. Baker also alleges that the city violated, both procedurally and substantively. Procedurally, the first question is there a property interest or is there a liberty interest? He has neither, but assuming he does, that's not the end of the analysis. Governments can take property rights and liberty interest. You just can't do so without due process of law. And the city accorded him due process of law. Notice and opportunity to be heard. Notice that there was a probable cause finding, again, both in employment and housing. He's never contested the housing based on race and marital status, given him the opportunity to be heard. A fair and impartial administrative law judge, a private attorney here in Des Moines that the city contracted to hear the case. That's notice and opportunity to be heard. Clearly, no procedural due process violation. Substantively, that's reserved for the most egregious actions by a government. So for Mr. Baker to prove his case there, that would mean that a city who has chosen to hold all employers, large and small, from making employment decisions based on one's race, one's gender, one's color, shocks the conscience. It clearly does not shock the conscience.
Well, I guess to put words in his mouth, and in rebuttal he can correct any errors I make, but I think the claim would be, well, wait a minute, you didn't seriously investigate this, really, and we had excellent defense. Our defense was, number one, we didn't hire this particular person because she didn't provide references, and had you looked at the facts, you would have known that. And secondly, the individual was going to have a 10 or 11-year-old son, apparently do the upkeep and so forth and so on. And so had the city even dug beneath the surface, we would have abandoned this whole thing. We wouldn't have run up $70,000 of fees, but instead the city willfully and blindly proceeded because they have an ideological agenda. I mean,
First of all, he settled the case before the hearing, before all the facts would have come out. So there are facts unknown to Baker as part of the probable cause investigation that the investigator knew what the current resident manager thought and knew, and what the applicant thought and knew.
You're making an interesting point, and let me ask this. What does the record show with respect to the probable cause determination and the nature of the investigation? Does it show anything at all, or is it?
It does not. It does not, Your Honor. Just the nature of general and probable cause. Both the other side doesn't know what the investigator knows at that time. But at the time of the probable cause, then the files are shared under the city ordinances. The matter is set for hearing. A discovery is available. And last, just in terms of the equal protection argument, the city also did not violate his rights to equal protection. Those have somewhat morphed. In Baker 1, the two groups were small cities in Iowa, small employers within Iowa City, and small employers throughout the state. But of course, they're not similarly situated because the city has no jurisdiction outside the city. In Baker 2, the two groups are those groups of employers that the city has accepted out from its ordinance, much like Title VII in the federal situation and Chapter 216 in Iowa, and small employers that the city did not. But those are not similarly situated. The employers that the city accepts out, again, having to do with religious institutions and bona fide occupational qualifications. So they're not similarly situated. To the extent they're similarly situated, the city meets both rational basis, assuming the court finds a fundamental right at issue, and strict scrutiny. There's a rational relationship to the legitimate government interest of opening up the doors of employers. And in terms of strict scrutiny, it's narrowly tailored to serve a compelling government interest. Again, anti-discrimination being a compelling government interest, and it's narrowly tailored. There's only a handful, and even those are narrowly tailored. For example, if you want to have an employment that's an employer only wants to hire someone of a certain age, they still can't discriminate because of someone's race or religion. So they're very, very narrow, and it's narrowly tailored to meet it. And last, just the attorney fees issue. Again, attorney fees under Section 1988 are premised on a finding of 1983. So without a constitutional violation of freedom of association, free speech, equal protection, or due process, the 1983 claim fails. Without a successful 1983 claim, there can be no damages because a home rule violation based on conflict preemption, which was what Baker 1 decided, does not give rise to fees. Perhaps the Iowa legislature would like to do that, have some type of 1988 claim for violations of home rule in Iowa, but the legislature has not done so.
Well, let's talk about what the legislature did do, though, and that is limit the Iowa Civil Rights Act to exclude small employers. The Bonfield article does talk about freedom of association, and I fairly read suggests that the legislature made a judgment that certain small employers on their face involve a freedom of association that is worthy of protection. What influence should that legislative judgment have on our constitutional determination? Obviously, we have a freedom of association constitutional claim. Legislative action is not identical to it, but ought we not consider the legislature's choice in limiting the Iowa Civil Rights Act?
Right, but the federal government, under Title VII, it's 15 employers. So if under the federal government you don't get to associational until 15, well then is Iowa's illegal? Is Iowa Chapter 216 unconstitutional because employers between 4 and 15 are not accepted? It's just that some policy line has been drawn. That does not make it a constitutional violation that gives rise to fees or to give rise to an affirmative duty.
Look, let me explore your idea that, I mean, what I hear you saying is if it's a commercial relationship, there's not a constitutional violation. I mean, I think back in my long life, there have been several times where I was looking for housing and you go to the housing office at the school and there are those notices that say so-and-so looking for a roommate, $200 a month, or I'm sure it's more than that now, and then you'd call the number and you'd go over and the person would interview you and you'd kind of see if there's a fit or not, and if there was, you'd sign up for the year and pay the money and all that. And a lot of us probably went through that. Are you saying that that's not a constitutionally protected relationship, that a housing discrimination law in full force can be constitutionally applied to that relationship?
That would be cohabitating. And someone living in Pennsylvania, staying in Iowa City for a couple of days a year, which is what the record reflects, is not cohabitation, Your Honor, in the city's position.
With respect to your equal protection argument, doesn't the statute exempt certain employers?
Yes.
And one of those exemptions would be the personal service employees.
Right.
Wouldn't the claim argued in this case be similarly situated to that type of exception?
It would have been, if he's staying there, if he's claiming that he's actually living there, Mr. Baker, yes, but the city never came to that conclusion. But yes, Your Honor, that exception would apply, which is an exception also found in state law as well. For the reasons stated, the city requests that the court reverse the trial court's decision on the motion to amend, but affirm the district court's decision in its motion for summary judgment. Thank you very much.
Thank you as well, counsel. Mr. Pitton, you may present your rebuttal argument.
Try to cover a number of things briefly. The city and commission alleges that we didn't brief freedom of association, which of course was addressed in the Baker 1. I would refer the court to Appendix 129 to 132, in which you'll see that there were a listing of briefings and matters addressing freedom of association and freedom of speech. With respect to the personal relationship here, a couple of points. In Board of Directors of Rotary International versus Rotary Club of Duarte, the Supreme Court said, we have not held that constitutional protection is restricted to relationships among family members alone. To meet freedom of association, we aren't limited to goals of marriage and children. Instead, we look to the Roberts factors, which, as we discussed, size, purpose, policies, selectivity, and congeniality, which we've addressed previously as well. And the court talks about between the two poles of families and large corporations lies a broad range of human relationships that may make greater or lesser claims to constitutional protection from particular incursions by the state. And that's what we're looking at here. City and Commission assert that there is no affirmative right to freedom of association. It's only a shield, it's only a defense. That makes 1983 civil rights protection meaningless. If the civil rights of the United States government were restricted only to a shield and defense, then the ability to challenge those rights would essentially be undermined.
Well, but what do you make of Norwood and Runyon then? I did take a look at them. They're kind of older cases, 173 and 176, but they do, I mean, it states kind of baldly in those cases that freedom of association has never been accorded, quote, affirmative constitutional protection. Are you asking us, has the law moved beyond those cases, or has the city misread the cases?
I believe that they can be distinguished and that they were misread. Those cases, as I recall, relate to invidious discrimination that had occurred under those circumstances. That's not what we're talking about here. We're talking about a husband and wife trying to pick somebody to run the family home. So we don't believe that those apply to this particular instance. The City and Commission challenged the property and liberty interest here. The district court did find that property interests were affected of the Bakers, both in terms of expending substantial time and money in defending themselves by the city's continued pressing action, and also the interference with their business. So those findings are entitled to recognition as well. Due process, procedural due process, goes far beyond the requirement of notice and an opportunity to be heard. As indicated by the court in Carlos, state enacted rights, when violated, become a 14th Amendment due process violation. And in Carlos, of course, we're dealing with the prisoner who had the right to 3 phone calls under state law, but the violation of that right then became a 14th Amendment violation, a federal violation entitling him to a 1983 award. Likewise, the Fields case we cited and Harmon versus City of Kansas City, this anti-solicitation ordinance then resulted in 1983 liability.
What state law gives you a property interest?
The specific statutory, property interest arose from the expenditure of funds and money as the court in the Bakers defending the action, number one, and secondly, the interference with their business activity in this particular case.
Boy, I mean, correct me if I'm wrong, but ordinarily, fees that are racked up in dealing with government do not give rise to a property interest, I don't think. I mean, sometimes it can be expensive. I mean, you can go before a zoning board and complain about a sign or whatever, and you can hire an attorney to go with you and kind of help you on it. It's probably a mistake for a zoning board, but when you're dealing with the city, fees get racked up, and the same with state government, general, and even federal government, maybe even more so. But ordinarily, the fact that you incur expenses in legal defense has not been held to be a property interest, I don't think, absent the statute, of course, that says you're entitled to recover fees. Can you help me there a little bit?
Certainly, Justice. In this case, the district court did find that it impacted a property interest by virtue of 2 circumstances. One was the expenditure of time and money in the defense of this ongoing litigation, on multifaceted litigation. And the other aspect related to the direct interference with the Bakers' ability to run their business. So we have something broader than just spending money to defend. So for those reasons, we would ask for the relief previously requested, and that the court find that the city's action in adopting an unconstitutional ordinance, the Commission's action in prosecuting the Bakers under an unconstitutional ordinance, renders the city liable as a matter of law for violation of their fundamental rights. Thank you very much.
Thank you as well, Mr. Pitton. Ms. Dulek, thank you again for your argument. Well, that concludes the official business that we're on campus to do this morning.